Sorry, not.
Hello, everybody. My name is Jarek Buchholz. I'm founder of the Canada Real Estate Investors Club, Street Smart Real Estate Investing. And we are so proud to have our team from DC and Mr. Timothy Grier. Hello, Mr. Timothy. How have you been doing today?
Very good. Good to be here.
Pleasure. Thank you very much for sharing your time. And, so what are you going to be covering today?
Well, I'm going to be talking about a current view of real estate law in British Columbia. Bear with me, it's my first time to try doing one of these things, so if I look strange or off in the corner, it's because I'm a little unused to webinars. I'm used to receiving webinars, not giving webinars. I was careful to name it 2018 Issues Overview. What I say today is correct today for British Columbia. I can't give advice for 2 years in the future. And although the law may be similar in Alberta and Manitoba and places beyond, it is not the same. So you need to be talking to a lawyer, a professional in these areas if you have a specific question in your jurisdiction and in the time after you have seen this video. I understand Jarek runs these things on a loop, so I will pop up in computer land some days, hours, millennia from now. Okay?
We will be doing many presentations, so please do not worry about that. And that presentation will be available on any media possible, right, within the time frame which will be defined by yourself. So why won't you just not spend much time? Just let's jump into the presentation, and it's all yours.
Okay, let's go to our first slide. This is a representation of life in BC. It's another quiet year. Nothing's changed, and yet everything changes. There have been many things going on in British Columbia, and I try and cover these. I wish to say that although it's not like a rocket ship, at times for those of us who practice in the area, it does feel like it. Could I have the next slide? Okay, I will be covering two areas. The start, I will focus primarily on residential, meaning single home, strata unit, vacation property. Typically, these can be really quite a quick turnaround. If you're selling in a hot market, or for that matter, buying, it can be as short as a couple of weeks or even shorter. Later in the presentation, I'll get on to commercial, and I will talk a bit about multi-unit and apartments and businesses with a real estate component. And these, frankly, can take months or even years to bring to fruition. One needs to spend more time and more effort trying to get yourself in the position to buy. And for those on the selling side of the ledger, it can occasionally be a frustrating process while you wait for your ideal buyer to come along. So two very different sort of time frames, two very different kinds of outlooks. Next slide, please. So who is who? When you buy, you can buy in your own personal name, husband and wife, family unit, perhaps brothers, sisters. You can also buy as a corporate entity. You can be buying as a company or perhaps a joint venture of several companies. A little bit about when one buys. Do you buy as a sole person, or when you bring someone on with you, are you what we call joint tenants? If you are joint tenants, you're playing the true survivor game, meaning when the last person is left on title, that is the one who owns the property. The other way of registering on title is tenants in common, which means percentage ownership. For families, very, very commonly, people will buy as joint tenants. There are advantages to that. There's simplicity at the time of probate. For corporate partners, that's less advisable. More likely, it'll be some kind of percentage sharing ownership arrangement. For sellers, one asks who is on title. You do a search at land titles. Occasionally you'll discover that the person who is selling has passed. In other words, it's a sale being made by the family of the person who has deceased. And the question is she able to sell to you? I have on the screen, is mom dead? Is mom incapacitated? Let's take the second question first. Suppose mom is, there's Justin, who's hard at work. Is mom unable to grant you title? So the question becomes, is there a power of attorney in place? Has mom made arrangements such that her son, daughter, husband is able to sign the transfer documents when completion comes? That's issue one. Issue two is, has mom passed away? If mom has passed away, you're in a very unfortunate intermediate position. Mom not being with us cannot sign the transfer, and you do not have a person with status to sign the transfer for you. Occasionally, sellers will get themselves into a whole world of hurt because they get excited, is the wrong word, but they get talked into selling much earlier in the process than they should. So they engage a realtor thinking it's not a particularly big deal to get a probate status. And unfortunately it is. It takes at a minimum 3 months, more likely 4 or 5 to get to probate status. It is a formal court process. One must give notice to the beneficiaries. There are waiting periods. Then there's the formal application. Then there's the application to court. And even on a speeded up process whereby one goes into court to get a probate order, you're looking at several months. So you are the seller, the family of the seller who thinks it's not a big deal to do this. You discover you can't give good title to your buyer. Your buyer is literally in the minivan with the trailer following with all their furniture, and they want to move in. You found yourself in a accidental and somewhat involuntary rental situation, and it's not a good one. Most of the time it ultimately works out, but suppose, looking at it from the seller's point of view, the buyer does not have good credit. Their financing falls through. Perhaps they're going to get several months free rent at the seller's expense. Or even more negatively, this is much less likely, but suppose the buyer-to-be are some party-hardy people. They're in there in this indeterminate status. You've allowed them into the property because they have nowhere to go. It's just a bad set of facts all around. So if you take anything away from this presentation and you're in a scenario where you are going to sell, and the person who is on title, who is one of the registered owners, has passed, you have to have probate in order to be able to do the deal, to finalize the transaction. Next slide, please. I'd like to see Justin. Justin's hard at work, and he's working in our India office. It's just a small fixer-upper. Next slide, please. So when you go to buy a property, you have to ask, what else is there? You've made your offer, and you have to study the registrations on title. And I've done 2 lists, what should stay and what should go. Things like easements, Rights of access almost always stay on. They're called a whole bunch of Section 219 land title registrations. These are typically things that were extracted from the developer when the house or the townhome was built by the local municipality. They're not controversial, and in almost all circumstances, they absolutely must stay. If there is a hydro line, perhaps there are rights of access, things like that will stay. There might be arrangements with the neighboring property. That's an easement. Power, cable, sewer, all of that will be covered off in the registrations. They're uncontroversial and frankly a little bit boring, although we lawyers get excited about them. You may be buying into a duplex, all right? Is there a party wall agreement in place? A party wall agreement is a legal document filed on title which tries to anticipate how expenses shall be shared. You have a common roof, you share a wall, you share some other things. Will it be 50-50? Or perhaps if it's appropriate, suppose you have a duplex where one side is, say, 60% of the area and the other 40%. Very typically, the party wall agreement will have language to reflect that. So a major repair will be mostly borne by the larger entity on title. For the most part, what is on the left side lease will stay. If there is something that you find intolerable or unacceptable, that will be a point where you say, thank you, I don't wish to continue. So here I guess I'd better make my comment about, are you making your offer with or without subjects? I'm speaking from the point of view of the buyer. You should always have, or at least I would hope you would always have, at least one subject to clause. The classic one is subject to financing. But another good one to do is subject to review by your legal professional, who will then look at the registrations on title. A classic sort of example is you're buying a home and there is a green space in behind, and is there a creek? And if there's a creek, there are Department of Fishery rules, and you cannot build too close to the said creek. And the setbacks have been expanded in recent years, and occasionally it's a bit of a surprise to people to discover that their large yard is mostly unusable for anything other than grass or a garden, and you cannot, for example, build a permanent structure because you are prevented. And that could be an absolute no-go area for some buyers, okay? And if you have the proper subject clauses in place, you can just gracefully say, well, thank you, we just don't want to be dealing with this, and we will look at another property. On the right-hand side of my list are things that are always taken off. Is there a mortgage owned by the seller? That'll be taken off at the time of completion. Is there a judgment? Are there builder's lien claims? Are there certificates of pending litigation? A certificate of pending litigation is the formal registration. It just says there is a lawsuit of some kind claiming that in some way the property is bound. It's a kind of security. Now, you, the buyer-to-be, you don't care about it. You just want it off. If you're particularly spooked by it, maybe that'll be a reason not to buy. For the most part, it's just an issue that the seller has to deal with. Is there an agreement for sale? Is there an option to purchase? These are rights in the land recorded as a registration on title. One wants to have these cleared off. In fact, you absolutely must have them cleared off. Now, occasionally this becomes an issue because you have a seller who gave an agreement for sale or an option to purchase to some other party years in the past, and the deal didn't finalize, and frankly, they forgot it's there. The old buyer-to-be, the option E, does not wish to proceed. All is fine, but the current new buyer does not want that registration on title. So as part of clearing title, the lawyer acting for the buyer will say, well, we want this cleared off. And this could be a big issue for the seller if the person or entity that possesses the agreement for sale rights, the option to purchase rights, can't be found. It's possible to imagine, in fact, I've encountered it in my career, where you have a right that was granted in the 1980s or 90s. It's literally decades later. The person who did have an interest is either dead or has moved to Ontario, and in any event cannot be found. You've got yourself a bit of a problem. And in a worst case scenario, the buyer must go through great gobs of effort and perhaps an application to court to say we have done this, and this to try and find the former person who had an interest in this option. It still exists. It still binds the title. We want it off. And you have to get a judge to grant the order. It's quite a big deal. So I guess for sellers who are looking at this, please check your title before you list for sale. Make sure it's just ordinary stuff. And if there is some lurking agreement from the past, before you list, go and find the possessor of the right, however unlikely to be exercised or unfortunate as it may be, and sort this out. Occasionally, it's a very simple thing. You just do a registration that says, by effluxion of time, there's a nice legal easy word, by effluxion of time, this is no longer effective, and we ask it to be cleared off. But in other cases, it is an active right. It is still there, and at least in theory, the possessor of the right may wish to enact it. They may wish to carry through on the option or the agreement. Once in a while, I have people come to talk to me at this very preliminary stage, and they say there is this old option to purchase, and as most of us are aware, the values of land have risen in British Columbia. I work and live in Langley, BC, and we've gone through significant increases in the prices in the last 3 years. And if one looks historically, we've gone through dramatic prices in the last 30 years. It's been a fairly steady climb. So if someone possesses the option to purchase a property, that could be a very valuable thing. And they may say, well, I guess I would like to purchase that property for the price, which was a very grand figure of $200,000 that was set in 1992. And that's a great thing for the buyer to be if the current value of that property is $800,000 or some higher figure. Now, most options to purchase are drafted such that they will expire, or that there is a condition that had to be fulfilled at some time in the past, and that is not a great worry, but you do need to check. Lastly, is there something off title? Occasionally you get wound up because there are Canada Revenue Agency demands. There are things that tie up the title without the knowledge of the seller. So again, for sellers to be, get your house in order before you list it, because there may be some nasty surprises to come. You may lose that perfect buyer if you have trouble clearing title when it matters. Next slide, please. GST. GST is a not terribly lovely tax that people are not terribly fond of. I have an excerpt from the Act, and I asked, does it apply to the purchase price? I will just say that if you are dealing in land, it may apply. If you are supplying new property, it will apply. Next slide, please. Essentially, it's a tax that depends on the status of the seller. If you're selling a used residential property, no GST applies. It's nice, straightforward. Sell one house, no GST. Sell two, no GST. Sell five? Well, now we're on to something. Maybe you are. Maybe you have become a dealer in land. At some point, one is a trader in land. Whether you intended it, you are a kind of developer. My next point, new build by a developer, absolutely there is GST that applies. It's a new development. Actually, go back one slide. I wish to go over section 9B. At 9B, it says, a supply of real property made in the course of a business of the individual or trust, or where the individual or trust has filed an election with the minister. That's the minister in charge of Canada Revenue Agency in prescribed form. And in the course of an adventure or concern in the nature of the trade of the individual or trust. Okay, go forward. What this means is that if you are a business person who is making their living buying and selling land, you're going to have to understand what's going on with GST. For most buyers, you just want a declaration that the seller lived there, or perhaps they had it as a rental property, and there are other people living there, and they can confidently say GST does not apply and no issue. When one does the closing, what one wants to do is make sure that the GST is covered off in some way, which is by this very ordinary declaration. Occasionally, clients get themselves tied up in knots because the issue of GST is rarely addressed in residential contracts of purchase and sale, and you get into a bit of a argument about, well, who has a GST obligation if it's one of these iffy questions. So be aware of that. Next, acreages. Is it farm status or not? One has to know what one's buying, at least be aware. Now, GST, New Housing Rebate. It applies to realtors' fees. It applies to conveyancing fees. It applies to new builders. Question, is it included in the price or not? Who has to apply? Most typically, it's the builder, but it's not always the builder. When you're selling in a hot market, and we've experienced some of that here in the Lower Mainland, occasionally builders say, no, we're not going to bother. You, buyer to be, you do it. Now, most will do it. It's a thing that one can have systematized. The builders do it for their 8, 10, 20 units, but not all builders are that nice. You get a GST exemption for the principal residence. You can only pick one. GST rebate up to $450,000 of a new build rather. It's clawed back on amounts up to $517,500. So for buildings larger than that, you just pay the GST 5%. Not very great. Next slide, please. From the Canada Revenue Agency website, find out if you're eligible for the GST HST New Housing Rebate. And just look at where these on the website, you go to where it's highlighted. It's your primary place of residence. It'll be cooperative housing. It's a qualifying mobile home or floating home. There is a place called Grant's Landing, which is about 6 miles from where I sit. And people are floating on the Fraser River. What a bizarre concept, but that is what they do, and it's actual housing. And then there's a reference where you can go to check out the new housing rebate. Just a side note, this isn't exactly my presentation, but I wish to say that in this age of the internet, government agencies have all kinds of fantastic information on the web. Look up what Canada Revenue Agency has to say. Look up what our provincial government has to say. Generally, with a bit of effort, you can find out what the base rules are. You can inform yourself and inform consumers and inform sellers, make for a better understanding of what can be done. Next slide, please. PST. Happily, it's not a big deal in real estate law. It applies to some of the disbursements. Disbursements mean things like The courier costs, tax on the documents used. It applies to conveyancing fees. Allegedly, it's used to fund legal aid. I say allegedly because our government's forever shortchange the legal aid. About half of it goes to that purpose the last time I checked. If, when we get to the commercial aspect of this, you're buying a business along with land, and PST will apply to some of the equipment and some of the tangible assets. But in residential, it's a very minor issue. Next slide, please. Property transfer tax. I'm going to spend a number of minutes on this because this has been a big deal and a moving target in British Columbia. I started practice in 1998, and for years and years, this was the rule. You spend 1% on 1% of the first $200,000 of the purchase price and 2% everything above, and that's the way it was, and nothing ever changed. It's a good little gainer for our provincial governments. It's been around since 1987. It had a luxury tax justification. At that time, it is said that 5% of the homes were over the $200,000 threshold to hit the 2%. So just a few homes, basically in Vancouver and Victoria and perhaps North Van. Times have changed. Now, so you have to pay this, and the issue is, can you get an exemption? Exemptions are only for natural people. I see I must have done some editing and taken out of a line that talks about exemptions. Anyway, if you can get an exemption, you do. It's only for people. It's not for companies. It's only for BC residents. So those of you who are watching this in your home in Canmore or Calgary, unfortunately, you don't qualify. You have to live in the grand exalted state of British Columbia. We're trying to sell you some wine, I hear, and perhaps you're going to sell us some bitumen. Anyway, you ask, is an exemption possible? First-time home buyer, yes. Transfer to a spouse, yes. Transferring up or down generations, yes. Transfer to an executor as part of a probate, yes. Next slide, please. There is a website, as I said, you can find out these things. Mostly look on the left side where it's got the highlighted things where exemptions are possible. At the time of the transfer of property, transfer of principal residence, transfer of a recreational residence, transfer resulting from a marriage breakdown. That's a nasty one, but at least when couples are divorcing, when they're breaking up, the party of the two who perhaps buys out one and does not get dinged by property transfer tax, because then you will cease to be a married couple. Small practice point, you have to have a separation agreement drafted and in place in order to achieve the status to qualify. Transfer of a family farm involving individuals, transfer of a family farm to or from a family farm corporation. On the right hand, in very small print, are other exemptions, newly built home, which I'll get to in a second. An interesting one is company amalgamation. When we're on to corporate life, if a company owns two adjoining properties and one company owns one and a different company by its same or similar owners owns another, if you amalgamate, you have the right to avoid property transfer tax. Here's an interesting exemption, transfer following bankruptcy. Kind of a nasty one. They know there's no money there. Next slide, please. Related individuals, another website that I've used. First, focus on the right-hand side. I was mostly talking about property transfer tax. You can transfer to a related individual. This means child, grandchild, great-grandchild, and their spouse. Your parent, your grandparent, your great-grandparent, your spouse, their child, their parent, their grandparent, their great-grandparent. Note that a child includes a stepchild. Basically, you can transfer up or down the generations. That's how I remember when I'm trying to ask myself, do they qualify? It must have been a policy decision made back in 1987 that They will not allow it between siblings because often siblings go into business together. That's the only way I can figure it out. Now, left side of the screen, homeowner grant. Every year in June, you will get your property transfer tax, your property taxes, and you will qualify for a homeowner grant if it's a related individual. And if you live together, your child, your grandchild, your brother, sister, or parent. So for this purpose, being a sibling is okay. So you do have to check which act and which taxing authority you're dealing with. And I discovered when I was investigating this, you can qualify for a homeowner grant for people with disabilities. It includes a step-parent or grandparent or a person standing in the place of the parent of the person with disabilities. So there are some breaks in our tax law on these matters. Next slide, please. March 2016. Some changes. This is when the new build exemption came in. This was a big deal. It was to stimulate construction primarily of townhomes and condominiums. So the government giveth. To the end user, it was fully exempt for values up to $750,000 and partially exempt up to $800,000. This worked great out here in the valley. All kinds of townhomes and condominiums are being built for less than that figure. That's still a sizable amount. There were changes that weren't so great, and that primarily affected large value homes in Vancouver, North Vancouver, and I suppose parts of Victoria. They increased it to 3% for values over $2 million. Now, this was a change. Recall I said since 1987, it was 2% for everything above $200,000. So the government has decided that there is a chance to make some money, and they increased it to 3% for values over $2 million. Remember that figure, I'll come back to it later. Next slide, please. August 2016. Our government, at that time in a political panic, I don't know if you recall, this was a Liberal government, decided they were going to steal the thunder of the NDP because an election was coming, and they decided they didn't like foreigners. So they created a new surcharge for non-Canadians and non-holders of permanent resident status. All the forms had to change because how are we going to prove that one is a non-Canadian or a non-holder of permanent resident status? The answer is through the social insurance number. Now, I'm old enough to recall that the social insurance system was introduced, and it was supposed to be a thing that was only for some federal programs back in the 1960s, and it was never going to be an ID card. Well, guess what? It is an ID card, and that is the primary purpose. Anyway, so the forms had to change. There was a great scramble. There was no grandfathering of deals in the pipeline, and it caused a great deal of injustice, in my view. So it's about the 4th or 5th day of August 2016. It's still 1% property transfer tax up to $200,000, 2% $200,000 to $2 million. The new, as of March, 3% over $2 million. Plus, if you are a non-Canadian or a non-resident, this 15% surcharge on top of the price that you are going to pay. Now, this caused quite a bit of hardship. Contrary to the rhetoric, not everyone who was coming to buy was a wealthy individual from Beijing or Taiwan. And there were a number of very hard cases that made the news here where people who had literally gathered up all of their money and just barely qualified for the mortgage and made the down payment, and they lost it because of this sudden and dramatic change of legislation. They also brought in some anti-avoidance provisions because they know that there were going to be some dramatic pushback on this. If one misfiles, euphemism, if one on purpose tries to hide your status and it's discovered later, the purchaser must pay the tax. The main one people are trying to avoid is the 15% tax for not being Canadian. And there are fines possible, $200,000 for a corporation, $100,000 for an individual. And then it goes on to say that it could also be up to 2 years in prison. I actually question if that would ever happen, but it is legislation that's on the books. And theoretically, if one is an individual coming in from outside the country, you could have 2 years in the clink waiting for you. I don't think it would happen, but that is a potential penalty that is put in the legislation. Next slide, please. Time marches on. Our provincial masters have changed. We now have the NDP who govern the store. Effective February 21st, 2018. Things have changed. I would like to do a shout out to the BC Real Estate Law Development's publication. I depend on them for a number of the bits of information I've included in the next number of slides. Okay. Recall it went up to 15% outrageously in August 2016. Our new government has to establish that they're bigger, tougher, meaner than the previous lot. So now it's 20%. If you are buying and you're coming here from Malaysia and you're not Canadian and you don't have permanent residency status, you're going to get whacked 20% for the privilege if you wish to buy in the following areas, which are broadened. It now includes the Fraser Valley, Nanaimo, Victoria Regional District, Kelowna, and Kamloops, basically every major population center in British Columbia. There has been a bit of learning. There's a 3-month grandfathering this time, so we're actually in that period. So if there's a deal in the pipeline that was set to close, say, April 25th next week, you can avoid this, remember, increase from 15 to 20%. So it's still going to hurt if you're a non-Canadian. Next slide, please. Okay, a little more on property transfer tax. Also, as of February this year, if the assessed value is more than $3 million, now there's 5% property transfer tax on amounts above $3 million. Again, going to Victoria to be used for general revenues, all being used wisely, of course. And now, annual taxes, the amount above $3 million will be increased. Any residential will include also multi-units. The details are a bit unclear at the moment. We're waiting for clarification on this. So that's one of the reasons why I said it's what I tell you is current as of today. Some of the things in the next number of slides are things that are coming. Next slide, please. So in the more to come section, the current government has made a great deal of hay about the speculation tax. It's coming in 2018. They say it will target foreign and domestic non-income tax payers, which is a grand way of saying if you don't have a job here in beautiful British Columbia, you are going to be eligible for 5% on every $1,000 of assessed value, and it will increase gradually to $20 per $1,000 by 2019. The details are unclear, but it doesn't sound good. For Metro Vancouver, Fraser Valley, Capital, and Nanaimo, Kelowna, and West Kelowna. Again, it's still a source of some controversy, and it hasn't been reduced to legislation yet. Other measures. The government is beginning to require developers to collect and report information about the assignment of pre-sale condo purchases. There's been a great stir here in BC about flipping, which is where one party would sell to another. On that, I guess I can say I'm quite sympathetic to the authorities. The purpose of this is also to share information with the tax authorities, provincially and federally, for better coordination. This is to help them shear the sheep more efficiently, we being the sheep. Next slide, please. Next slide, please. More changes. Beneficial ownership. When one owns the property, one can register it in trust. Usually this is a private document. Our government is talking about making this a publicly accessible registry of beneficial ownerships. I guess I can get on with the policy reason driving it. They want to be more efficient in their tax collection. They want to stop money laundering. They want to stop people turning, for example, drug money into, quote, clean money. Question whether people who are actively into this sort of thing will not figure out how to do various false declarations about their beneficial ownerships. Nonetheless, there's more to come, and they will be amending the Business Corporations Act and other acts, and this is supposed to come in 2018 or 2019, so this is a stay tuned one. Homeowner grant, the threshold is up from 1.6 million to 1.6.5 million, and a clawback of the homeowner grant, $5 per $1,000 in value, up to 1.65 million. Now, you'll notice that's quite a high value if you're watching this from Saskatchewan, where I grew up. This is an astonishing figure for a house, and this is a fairly common figure in Vancouver today. Next slide. Quirks of the property transfer tax. From the start, I believe it's from the start, acreages were eligible for the exemption if you qualified, but it's only on the first 1.24 acres, 0.5 hectares. In effect, it's the most valuable bit, the section with the principal residence on it, but the areas outside of that half hectare are fully eligible to be have the tax. Now, what else goes on? People try and work around this tax. Guess what? People don't like paying the tax. So if you have, the classic is you have a first-time home buyer, neither the husband nor wife have bought before. One of the parties will buy and they will hold the property, and at some time in the future, they will transfer from the one to the two of them jointly. It requires some maneuvering. It requires a second land title filing. The property transfer tax arm of the government does check. The audit provisions of the Act do apply. It's at least a year before putting the title into jointure. If people are going to go to this effort to do it, I suggest you wait more than a year. Probably the year is going to be expanded. And if there's no issue in the marriage, there's no particular pressing reason to do it unless one of the or the other has health concerns, and you're thinking what happens if the partner should die and you're looking at an accidental probate that you didn't intend. Next slide, please. Some oddities about the property transfer tax. Recall I've gone on for quite a bit about this surcharge for foreign buyers. Astonishingly, Squamish and Whistler were missed. So the only good explanation is that lots of Americans buy in Squamish and Whistler for their ski chalets, and the government didn't want to rustle feathers further south. Another thing that's odd is, perhaps I've explained it on the slide. The exemption, it only applies to residential. You're only going to get an exemption if you're trying to buy as a person. Commercial deals are still open. So the government has gone through all this effort to keep out foreign money, or at least to try and cool the market is the language. But commercial deals, no problem. So if a non-Canadian buyer wishes to buy a strip mall, it doesn't apply. It's a commercial deal. If the goal is affordability, it seems to me that you should compel Vancouver and other areas to increase density, plain and simple. You increase density at some point, the power of Adam Smith's market should start to kick in, and the crazed jump in value should cease. But that's just my view. Next slide, please. Capital gains. Capital gains is a wonderful thing. Everybody has a lifetime's capital gains exemption equals to 400,000, half of the 800,000. Again, I've referenced a site where one can investigate. Next slide, please. Capital gains exemptions on principal residences. The government defines these quite carefully. I've gone through a list. You can claim the exemption on your principal residence, a house, a cottage, a condominium, an apartment in a duplex, a trailer, a mobile home. There's a houseboat yet again. Property has to qualify to be a principal residence. And one of the things that is changing is that the annual tax has you make a declaration. This is a new thing. Where is your principal residence? It didn't used to be there. The reason is, if you are so fortunate as to have two homes, you get to choose where you will claim your principal residence for tax purposes. Government wishes to know because they don't want you jumping back and forth, as people have done, depending on the vagaries of the market. So those of us who are attempting to organize themselves in this way, be aware that the government is now tracking more carefully. Next slide, please. So planning, what to do. You're going to buy. Would you consider a corporate structure? Would you buy your new house to be under a company, for example? You lose the homeowner grant, you lose any property transfer tax exemption, you lose the capital gains exemption for personal residence. But you do gain some flexibility for a future buyer to buy the house, the property, to avoid property transfer tax. Now, this shouldn't drive every decision, but it's at least something to consider. The buyer-to-be can buy shares in the company. The company continues to be the owner of the property, and there is no change in the ownership, so you don't pay property transfer tax. It does create more due diligence issues for a future buyer. So even though occasionally people will have properties held in this way, that doesn't necessarily mean that the buyer-to-be wants to partake of it. So perhaps consider it, be aware it won't necessarily work. Next slide, please. Probate scenario. Someone has died. People ask, well, what is probate tax? It's nothing on the first 25,000, 0.6%, 25 to 50,000, 1.4% above $50,000. If you transfer a home into jointure, as I said earlier, you will avoid probate. Classic scenario, the senior dies, and then the home is smoothly transferred to a son or daughter, grandson, whatever. But I do caution, smoothly is in the eye of the beholder. Occasionally, this is seen as improper or unjust in the eyes of other sons, daughters, relatives. So if you're going to do it, be aware of what you are doing. The classic scenario is where one child gives more care to mom and dad in their last years, and lo and behold, upon the death of the senior, other children discover that the home, which was the sole large value item in the parents' financial life, has passed to the one caregiver child. There's the classic sort of scenario where litigation may ensue. But I will say, as a planning thing, it is a very good way to avoid having to do transfers, to avoid doing probate, but you want to at least have considered the various family implications and tried to make sure that people are aware of your plan and are not about to jump into litigation mode upon the dying of the senior. Next slide, please. Commercial scenarios. Now I'm going to shift gears a bit. Think about primarily from the viewpoint of a buyer to be, but also I'll suggest what sellers to be will be thinking about. So my first scenario, suppose you're going to buy a multi-unit rental building. How is it different from a single house or condo? Next slide, please. Well, there are tenants, and occasionally there are tenants with differing issues. But I'd share some of my research here. Anyway, next slide, please. More seriously, you're the buyer. You're going to buy. So you make your offer. It's subject to financing. You line up your financing. You should be having a very thorough building inspection done. You should be checking out the zoning. Is the property zoned correctly? Like, is what was built what is actually approved in the area? In 99.9% of the cases, the answer will be yes, but you still should check. The building itself, is there any unauthorized renovations? Has the last owner, the current owner, done a bunch of changes that perhaps they didn't share with the local municipal hall? Have those changes, if done, are they up to code? Sometimes some owners believe themselves more capable than they really are, or perhaps they just have cut corners. So you, the buyer to be, are you buying into a problem? Are you going to be discovering that there are a whole bunch of code violations? There is a number of things that have to be done. Therefore, you're agreeing to, should you take it over without checking, you're agreeing to a whole bunch of work and expense to make the building up to code. That's sort of part one. Part two, read the rental contracts. Very basic thing. If you're buying a rental housing establishment, are there proper written contracts in place? Do they follow the Residential Tenancy Act? There is a Residential Tenancy Act here in British Columbia, and if there is no contract, there are default rules that you are statutorily imputed to have accepted. And they're not unreasonable particularly, but if the owner of the property that is selling didn't create proper contracts, you can have a bit of a muddle. And one thing I always ask and tell clients is, having read the contracts, make sure there is the right to inspect these properties, these rentals, on 2 days' notice. That is what is correct according to the Act, and more importantly, as a self-preservation sort of idea for the owner to be, a grow-up can create the crop in 3 months, and the humidity caused by said grow-up is frankly disastrous for a house. It will cause all kinds of humidity and hence mold issues. So you want to have the right, and when you become the owner, you want to exercise that right to get in there and inspect. Make sure it's not happening. But before you buy, you want to make sure you have the right to be doing this. Next slide, please. So you're buying a commercial or industrial building, some kind of strip mall scenario or some kind of industrial building. You've done a financial analysis and you're reasonably comfortable that this works for you. And you ask yourself, or you are at some point told to ask yourself, what is dirty dirt? Next slide, please. The Environmental Management Act. what is dirty dirt? A contaminated site means an area of land in which the soil or groundwater lying beneath it, or the water in the underlying sediment contains a prescribed substance in quantities or concentrations exceeding the prescribed risk based on numerical criteria, standards, or conditions. These are set by regulation. The former act was called the Waste Management Act. This was a new thing when I was an articling student back in the late 90s, and now it's quite a standardized thing. The criteria are set from time to time, and I can tell you there's only one direction, that is up. They get stricter, meaning less of the prescribed substances. And so you ask, whose problem is it? It's the problem of the owner, the person in possession, the person with the right of control. That's not necessarily the registered owner. Think about what I said earlier about trust. Perhaps the actual directing mind of a property is someone who isn't officially on title. In any event, whoever controls the use of the real property, and it includes someone who has an estate or interest, legal or equitable, in the real property, but it does not include a secured creditor. I'll mention that in a second. Next slide, please. So, if there is some kind of environmental problem, the following persons are responsible: the current owner or operator, and, this is fairly striking, a previous owner or operator, or someone who produced the subject by contract, agreement, or otherwise. Think about, classic one is, think about a repair shop. All right, so you're taking apart motors and such, and there are all kinds of substances that come out, and if some of this is being spilled on and then leached into the soil, you have a problem. In addition, the following people are responsible: the current owner or operator of the site from which the substance migrated. Think about the scenario where you have the neighbor up the hill in some way who has an environmental problem, and that problem has been on the move downhill to you, to your property. A previous owner or operator from which the substance migrated. Next slide. The idea of this is that all kinds of people may be drawn in depending on the circumstance to clean it up. Someone who had a connection with the property you're going to buy, or the neighboring property that produced the subject, or in some way is responsible, or after the fact in a law case, held to be responsible for causing the environmental degradation. Now, a secured creditor is also responsible if they at any time exercise control over or impose requirements on any person in the manner of how to treat, dispose, or handle the substance. If the secured creditor becomes a registered owner in fee simple of the contaminated site. Now, this leads to consequences. When one, talking about not the cleanup so much, but when one is getting financing, which is usually a big part of the steps to buy a property, you will see and you will have to sign various representations and declarations for your bank or credit union, or if it's a private lender scenario, I hope for the private lender, for their sake, in which they say that you, the buyer-to-be, the borrower-to-be, are getting money for the purchase, but you are solely responsible for any and all environmental cleanup, environmental care, environmental problems. And that is how our lenders stay out of having to do this. And you think about the policy behind it, it makes sense. You don't want the whole lending industry to grind to a halt because banks are reluctant to extend creditors to business owners. So that's why there is this carve out in the legislation. Next slide, please. Now, secured creditor is not responsible for remediation if it primarily to protect his security interest. And this is what I was just talking about. If it participates in purely financial matters related to the site, and you can bet your bottom dollar that that's how they're going to word their lending. And they're not going to ask for capacity to or ability to influence the operation of the contaminated site because they don't want to drift into this control issue. Next slide, please. So what do? Again, this is from the Act, Section 46. The following persons are not responsible for remediation of a contaminated site. An owner or operator who establishes that at the time they became the owner or operator that the site already was contaminated, that the person had no knowledge or reason to suspect that it was contaminated. And here's the key bit. The person undertook all appropriate inquiries into the previous ownership and uses of the site and undertook other investigations consistent with good commercial or customary practice at that time in an effort to minimize potential liability. This means that you actually investigated, you made inquiries, and you have a paper record in the form of reports and investigations and declarations to show that you checked out the site. Remember, I talked earlier about the sections talking about migrating contamination. Think about the neighbor scenario. If you buy into a site and you have done the proper due diligence to show that it was clean so far as you were aware or able to establish that it was clean, and some years later you are doing a rebuild of some kind, a new construction, and PCBs are found on the site, you got yourself a major problem. Perhaps you have not exactly the solution, but the person to make claim against being the neighbor upstream who might be the source of the degradation. Next slide, please. So, if the owner was the owner of the site, the person did not transfer interest without first disclosing any known contamination to the transferee. That's you, the buyer-to-be. The owner did not, by act or omission, contribute to the contamination. The owner-operator owned occupied a site at the time of acquisition was not a contaminated site. So, I won't read all of it. Next slide. Basically, what I want you to do when you're buying a commercial property is to investigate. How do you do that? Well, you do what's called a Stage 1 remediation report. It's a big industry out here, all leading to environmental analysis. And typically, the Stage 1 is a reasonably minor financial step, $5,000 to $10,000. The company that does it, if you go to great Google and check, you'll find there are a number of environmental companies that do this kind of work, and they will do what's called a preliminary report. They'll dig some holes and they will check the samples. As long as they're up to scruff, you're okay. Your banks will be satisfied, you will be satisfied. But if they find something, then you're on to a Stage 2, which is a much bigger deal. Because a Stage 2, instead of it being perhaps a $5,000 or $10,000 hit, is a $40,000 or $60,000 hit to see what the problem is, what has to be done. Occasionally, it's a massive undertaking of digging huge amounts of ground, taking it off-site, cleaning it up, and either bringing that ground back or remediating the ground in a way that's acceptable. And the Ministry of Environment takes a very active interest in the property, as they should, because that is the purpose of this legislation. It could be a deal breaker if you are doing your commercial buy and you discover that the I don't know, for example, the $3 million property that you wanted to buy is a $3 million property with a $750,000 problem. You might still want it, but there's going to be some hard negotiation with the seller. And so sellers, this is a very big deal for you as well, because you can imagine how this will change your financial outlook on what you can get for that property if it's found that there is this large problem. Additionally, if it is reasonable to make a claim that the property is in this environmental problem because of the actions or dereliction of duty by a neighbor that led to the problem. Remember, groundwater is very much part of it, and groundwater moves. Whether this buyer proceeds with you or not, you may have investigations to do and claims to make regarding your neighbors. Next slide, please. So this is where I'm getting near the end of my presentation, but if you are doing a commercial purchase, you start with a letter of intent, or perhaps you start with a contract of purchase and sale with conditions and subject to clauses. As I said before, subject to financing, does it work financially? A thorough inspection about including environmental, checking the zoning. One thing I didn't mention, but I will say now, the community plan. Will you talk to the local community? Go to town hall, go to city hall. Do talk to the planning department. What is going to happen in your proposed purchase area? Are you buying a strip mall in an area that in the next 5-10 years is expected to become much busier? Well, that's a good thing. Are you buying in an area that has various access plans? It can be a good thing. It can be a very bad thing. If you're going to buy into an area that is going to be under construction while this new wonderful road is built and no one can make it to your business, perhaps you'll go bankrupt waiting for that bright future day. A good place to start is with the people who know what the plan is going forward, and that is the department at City Hall. Also, do some investigating. Who are the neighbors? Seems obvious, but once in a while people don't. And so there may be a neighbor who does something you find obnoxious to your proposed business that is 3 doors down. If you have the raucous pub next door, perhaps that's not where you want your senior care center to be. That is going to be full of people, you hope, who then will be calling and complaining to you about the raucous bar next door. So I guess what I'm saying is, my last line, before you commit, check, then check again. Next slide, please. More to consider. Commercial tenancies. Read and understand the agreements. These are much longer than the residential tenancy varieties. They generally are 40 or 50 pages long. Sort of hitting the high notes. What are the renewal dates for the tenants you are proposing to be the landlord to be? When it's up for renewal, is it the landlord's choice to accept the tenant again, or is it an automatic renewal right for the tenant? How many rights of renewals do you have, or do they have rather? Consider, will you be hiring a property manager? Will you be the property manager? Will you be hiring a management company? Is there an aspect of taking on employees? Now you're into a new area of law. Are you going to be giving those people notice and say, thank you for your time? Are you going to be requiring your seller to say, take these employees away? We want you to cover off their severance. Lastly, and this will be in concert with your accountant, we want you to ask yourself and get advice. Are you going to buy assets, or are you going to buy shares? Generally speaking, an asset sale is preferred by buyers and a share sale is preferred by sellers, but not always. Just a small note, when you're buying a share sale, then you're going to be investigating the history of the company? Are there any lawsuits out there? Is there any potential problem waiting for you? Recall earlier in the presentation that I said you at least should mildly consider when you purchase a property, are you going to put it in a company so that when you sell, you can sell it to avoid the property transfer tax by just having a change of ownership within the registered owner. That works very well if all you've ever done is add it as a holding operation, and basically it's a company that pays its taxes every year and not much else. If it is an active business, there will be a history, and perhaps there will be things that the buyer-to-be won't want to take on, or if they do take it on, they'll want to take it on at a discount and so forth. So I see I've gone over an hour's time, which was more than I thought I would talk. I would like to thank Jarek for giving me this opportunity, and I hope you have good success in your real estate future. Thank you very much.
Whoa. I made so many notes about all your references and everything. So for everybody who are watching and listening to these presentations, do not get overwhelmed. We will be providing all the resources for whoever will be interested about that. Can we agree about that, Mr. Timothy, right?
Oh, yes, there's lots to be thinking about.
Oh, a lot, a lot. You know, that internet is very powerful media. And I have a few questions. Are
Sure.
you okay to answer them? Right?
Very good.
Perfect. So one of our very active Canada Real Estate Investors Club member, Joe, I purchased a home through my Alberta registered corporation and sell that same home in the future to my child, who is a shareholder of the corporation. What are my tax and fee implications?
Well, first off, if it's an Alberta company, I have to say I'm just an interested observer because it will be according to Alberta law. So I'll change it into a hypothetical for British Columbia. In British Columbia, if a shareholder is buying into the company, you are taking on the obligations of the company. Mm-hmm. So you need to have a frank talk between father-son, father-daughter of what it is they're purchasing into. If there are tax debts, the company will continue to owe it. And if the company continues to owe it and through generational transfers, the second generation is now the holder of the bag, then the second generation is the holder of the bag. So you want to it's more of a tax question than it is a legal question. Legally speaking, the new generation takes over. But the company continues to owe what it owes, so you need to investigate what is the expected liability, and you need to have a frank discussion between father and second generation who is going to be responsible for what. Generally speaking, the second generation is willing to take it on because probably they're getting a discount of some kind from first generation to second. If they're not getting that kind of discount, then first generation is treating second like any other third party, and that's usually not the deal as between father-son, father-daughter. So there will be costs, legal costs, but primarily accounting costs to do with the investigation as to what's owed. Hope that helps a bit.
Okay. Joe, hopefully that you will get an answer. And then second and the last question for today is, does a person who claim for non-residency be subject to the foreign buyer's tax?
Yes.
Simple as that.
It's, I'll soften it up to this extent. If you are buying outside of the areas that I listed, but the reality is they have chosen virtually every area that most people who are trying to buy into British Columbia wish to come to. the classic example is someone coming from abroad, usually China, to Metro Vancouver, to Vancouver itself, and it's a big political issue, and that's why the government has come up with this policy, shall I say. I'll try and be somewhat neutral about it. I think it's a mistake. So there it is.
So thank you very much, Mr. Timothy, and I am so overwhelmed with the information you have provided, and looking forward for your future presentations. And thank you very much. And whoever is interested to reach out to Mr. Timothy, there is information iklaw.ca and phone number 778-289-9505. And if you will be having any other questions about other presenters, speakers, Canadian real estate investors, don't hesitate to reach out to our team. And looking forward for...
if I may, LK Law. LK, not IK.
Okay. Sorry. Okay, LK Law. Perfect. Yeah. Thank you very much. Looking forward.
Bye.
Pleasure, always pleasure.
And have a good day. Bye now.